rise. Place here in the court is now in session. The Honorable Judge George C. Ferris presiding.
You be seated. In the matter of Bonnie Martin versus Fuel Fitness Centers Inc., 45 Steel 11101 CT18. For the record, would anyone identify themselves and who they represent?
Good morning, Judge. Elizabeth Mannion for the plaintiff, Bonnie Martin.
And I'm Mark Lenup for the defendant, Fuel Fitness.
All right. We're here for final pretrial.
Yes, Your Honor.
Okay. We're set for April 1st for 2 days. Has there been any settlement negotiations? Are we anywhere with the settlement?
None that are successful, Your Honor.
Any mediation?
No, Your Honor, the parties did not think it would be worthwhile.
Okay. Any pending motions?
No, Your Honor.
There's a motion that we filed on September 14, 2011 to add a spoliation defense, and I couldn't tell if we ever had a ruling on that motion.
Is this filed?
Yeah.
Your Honor, we'd be happy to deal with that right now.
When was it filed?
Well, it says filed in clerk's office September 13 and then received September 14. It has to do with, this case involves an injury that occurred inside a vertical canning booth.
Looking for this motion here.
Got you see a copy?
Your Honor, plaintiff's counsel cannot find a copy of it either. I'm not sure if we received one. Maybe some others.
I've got 5 copies. We served 13.
The last thing I have in here, other than the free trial, is extension of discovery deadline, which was in October of last year.
Your Honor, I'd like to
Yeah, if you give me a copy. Sir.
I apologize.
Yep.
All right. You proceed.
Yeah, I'm not arguing the merits of it as whether or not it's a winner. I'm just...
Just that the goggles aren't there now?
Yeah, they're not there, and we raised that, and in our pretrial order, in the materials exchange, with the contentions, list of witnesses and exhibits, and in the pretrial order that was filed, we included that as a paragraph in defendant's contentions, and that was entered by the court.
Okay.
And, Your Honor, I believe spoliation only applies when it's intentional destruction of the evidence. The word intentional, I believe, doesn't truly apply here. Our client disposed of the goggles 3 months after the injury, long before suit was ever filed. It certainly wasn't to hinder trial in any way.
Well, like I said, the merits are something that we're going to bring up at trial, and we can argue on whether or not we get an instruction on it, whether or not we've established it. But I was just putting them on notice that we were raising a defense. And then...
Right, and I believe defense counsel today in jury instructions filed instruction number 5 related to that, and we would object to that and we filed a motion.
Do you have filed an instruction related to that?
We haven't filed any jury instructions related to spoliation of evidence.
Right.
We just received
Well, we can
them.
cover with jury instructions, but I think it's wrong.
Your Honor, then I guess, is this issue not being decided right now, or will be decided when it comes up at trial?
Well, the fact that she got rid of the glasses, that's coming in. I don't see how you can
Right.
out.
We're not objecting to her.
Whether it was an intentional to hide something, or that's another issue,
Right.
which we'll see at trial.
Okay, thank you, Your Honor.
Okay? All right. Anything else?
Well, we have our instructions. The court had ordered us to
File them today?
file them today.
All right.
We've given a copy to opposing counsel,
Okay.
and we also put them on the disc as the court requested.
Be able to file stamp them.
And Your Honor, plaintiffs filed it with the clerk on Tuesday.
Yours were filed?
Yes.
Right. I haven't got them up here yet, but if you file them, we'll get them.
Yes, with the disc, Your Honor.
All right. How many witnesses is the plaintiff planning on calling?
We believe likely between 4 to 5.
Yeah. Okay.
4 to 5?
Yes, Your Honor.
You only need to top bid on that was all that you gave.
Who are they?
It's not firm, but it would be our client, the defense, likely our expert, potentially a doctor, and one of the workers.
What were her injuries? You burned or something?
Had a finger and injury to her finger and hand.
Right, it was a finger that went into a fan above her head.
All right. How many witnesses do you have at the point?
Probably got 3 or 4, but they'll be brief. We've also got a video, Your Honor. Does the court have?
We have a TV monitor that you could use. If you want to bring your own, you just come in Friday before the trial. You could set up.
How about a video player? Do you have that?
Rich, ask me what video equipment we have.
And then, Your Honor, maybe you plan to go over this, but I just was interested in how many jurors you put in the box at one time.
Well, we put in 6. And then after we get, if you want an alternate, we'll choose the alternate.
Okay. And then, is it a one-pass system?
Yeah. To, we excuse the ones who you choose will stay on, and then we'll...
She said she thinks so.
You think so?
Yeah.
Excuse me, Your Honor, I'm sorry. Dave Hall will likely be trying this case. He's at another pre-trial conference right now.
Okay. All right.
And then on the perims, do you want us to bring our perimeter challenges to the bench on a piece of paper?
Yeah, I'll explain it to you as we let me go through a couple of other. How many exhibits do we going to have?
I think, and we talked about this just before, I think that we can get together and probably have a joint exhibit book. It's probably going to be about this much. I assume that they're going to do a summary for the medical bills instead of the actual medical bills. And then they might have some key medical records, but it wasn't an extensive.
So you're going to put them in a notebook?
If you're on for first, yes, we'd be happy to put a book together.
If you would, yeah. It'd be easier for the jury.
What we've got then are photos for exhibits. The photos of the tanning booth, and the various portions of it, and then a video of it showing how you turn it on and how it works.
Right, it would mainly be photos and medical exhibits on our end. Photos of booth and photos of the injury.
Okay, we're set for 2 days?
I believe so.
2 days? Yeah, I got 2 days here. All right. As far as the jury goes, I allow you to conduct your voir dire. Pretty much give you as much latitude as you need without going too far. Usually we pick a jury by noon. I mean, I don't see why this case would be any different. Challenge a juror, you come up, we argue at the bench if you want to challenge them for cause or whatever, out of the presence of the jury. And you write your preempts down on a sheet of paper and you hand it to me. We'll give you, I think we give you little forms. And that's pretty much all we do.
If we both use a preempt to strike the same juror, does that count as a preempt to both of us? Or do you have the plaintiff go first the first time and the defendant go first the second time we come up?
Well, you hand them to me, why don't you go plaintiff first, then the defendant.
Okay.
So I guess you know who the plaintiff struck.
I don't see a video in it, Judge.
There's no video player.
Just one of them old VHSs.
Yeah, we've got a disc. We'll bring one. No problem.
Yeah. You can come in a little earlier the Friday before and set up anything you wish.
Does Your Honor have any time limits for openings?
Well, that's where I'm going to get to.
Okay, I'm sorry.
Okay, we're going to one alternate. And then
Yes, Your Honor.
all right. We'll choose the first 6, then alternate last. All right, opening and closing. How much time are you going to need for opening statement?
I would think 20 minutes tops.
And closing?
Probably 15 minutes.
Let's do make it 20 and 20, I think. And counsel? How much time do you think you're going to need?
I think I'd put him to sleep more than 20 minutes. 20 minutes.
All right. The way I usually conduct a trial is start around 9 a.m. Take a break, maybe one break in the morning, and then we break for lunch at noon, and I try to be out of here by 4:30 every day. Okay?
Yes, Your Honor.
Okay, anything else we need to cover?
Your Honor, I don't believe it should, but the trial, if we conclude within 2 days, at the close of 2 days, is that an issue for the jury to come back the next day and deliberate?
No, we'll go till we're done.
Okay.
I mean, we should move it along, and I don't see why this case should take longer than 2 days.
It shouldn't.
It looks like there's anything, I mean, at the experts, you both, obviously there's going to be some expert testimony. Are they going to be live or by deposition? Or?
We'll have to confirm with our expert.
They should take long, because we,
Right, it shouldn't
Yeah.
take too long for an extra long session.
All right.
Thank you, Your Honor.
we'll get it done.
Thank you, Your Honor.
All right. See you April 1st.
All rise.